Hello and welcome to the presentation. First of all, I'm going to start with the first issue, which is the carrier's liability under the U.S. Maritime Law. For time limit purposes, and since the information on the issue is well known, the key information will be directly presented. First, what is deviation? According to Robert Force, the term deviation refers usually to two issues discussed in the U.S. Maritime Law. The geographical deviation, which is an intentional and unreasonable change in the geographic route of the voyage as contracted for. And there is, on the other hand, non-geographical deviation, which is also known as quasi-deviation. In the United States, the term deviation has also been applied to overcarriage, misdelivery, and unauthorized carriage of cargo on deck. Now, second, what does it reasonable and unreasonable deviation mean? COGSA provides that deviation intends to save life or property at sea, and all other reasonable deviations do not create a breach under either COGSA or the contract of carriage, and hence the carrier is not liable for loss or damage resulting therefrom. On the other hand, COGSA expressly provides that a deviation for the purpose of loading or unloading cargo or passengers shall be regarded as presumptively unreasonable. However, it doesn't specify the consequences of cargo damage or loss that occurs during an unreasonable deviation. The majority view is that deviation deprives the carrier of both the immunities and the rights to limit its liability provided in COGSA. The following Jones versus the Flying Clipper case law has provided a clear insight into how the deviation of the obligation stipulated in the bill of lading impacts the limitation of liability provided in the Carriage of Goods by Sea Act. Now, in the case in question, the court established the causal relation between the deviation and the seawater damage beyond reasonable doubt, and raised the question on whether unreasonable deviation by a carrier deprives it of the benefit of the $500 per package limitation of liability contained in the Carriage of Goods by Sea Act. The court emphasized that the answer is yes. That is because an unreasonable deviation displaced the bill of lading and thereby deprived the ship of the benefits of any limitation of the exemption contained therein, and made the ship or carrier responsible for the cargo as an insurer. The court emphasized the contractual nature of bill of lading and that departure from the obligation stipulated in the contract of carriage as to amount to an unjustifiable deviation renders the bill of lading and all its terms void. The court stressed that limitation of liability is not absolute and that deck stowage where under deck stowage is required is not similar to ordinary breaches of obligations under the Act. It is a deviation with resulting abrogation of the contract. The court eventually concluded that unreasonable deviation by the claimant respondent deprives it of the benefit of the $500 per package limitation contained in the Act, and that liabilities are entitled to recover their full losses. According to the information at hand, Standard Ocean Carriage has received the shipment in good order, and no exceptions were made. The container was stood above deck at the bow of the ship, contrary to the bill of lading, which stipulated that cargo must be shipped below deck. Causal relationship is established considering the fact that the damage reflected to the screens was a result of stowing the cargo above deck. Contrary, of course, to the bill of lading, which made the cargo subject to a significant level of salt air and salt water, regardless of the shape of the container used for the stowage. In addition, no third person was involved in the unloading since TPU Incoterms Incorporated, which makes the carrier responsible for the shipment from the time the goods are received from the shipper until they are unloaded and delivered to the consignee. As is the case with the Jones versus the Flying Clipper, stowage of the cargo above deck, contrary to the bill of lading, is a quasi-deviation, which abrogates the contract and deprives the carrier of the benefits of any limitation or exemption contained in COXA, and consequently makes the carrier responsible for the carriage as an insurer, and grants, of course, to the shipper the right to recover their full losses. Now, moving forward to the second issue, which is insurance coverage. As we concluded earlier, Standard Ocean Carriage is responsible as an insurer for the damaged cargo. However, these damages are supposed to be indemnified by Skull since the carrier is a member of Skull P&I Club and has a cargo coverage. Nonetheless, Skull has indicated it may not cover the claim because of deviation and because the cargo was carried on deck. Now the question which arises now is, does the Skull's rejection have a merit? This is what we are going to discuss following. First, we are going to discuss grant the trigger and any relevant limitations to the insurance policy. Paragraph 511 of Scott policy sets forth that the insurer shall cover the club member for liability arising as a consequence of cargo loss, shortage, damage, delay, or other responsibility. This obligation is triggered when such loss or damage occurs in connection with the carriage of cargo on the entered vessel. However, Skull doesn't provide this carriage at large, as there are limitations that must be considered. Paragraph 526 stipulates that carriage of cargo on deck is excluded from coverage unless one of the following is satisfied. The cargo is suitable for carriage on deck of the entered vessel. The contract of carriage contains an appropriate liberty to carry cargo on deck, and that the contract of carriage allows the carrier to load the cargo on deck, and that either the carrier is exempted from any liability for loss or damage resulting from carriage on deck, or the Hague rules or the Hague-Visby rules apply to carriage on deck. Moreover, Skull provides in paragraph 544 additional insurance to cover liability arising from, among other things, unauthorized carriage of cargo on deck, deviation, and some other types of departure from the contractually agreed voyage or adventure. Now, it's true that standard ocean carriage in principle enjoys coverage for its liabilities for loss or damage to cargo that it carries. This coverage is excluded in accordance with paragraph 526 referred to earlier, since the shipper's cargo was stored on the deck. However, standard ocean carriage will be qualified to gain coverage if one of the exemptions A to C satisfied. According to the information at hand, the cargo comprised of video screens which are highly sensitive to water and moisture. This means that the cargo is not suitable for carriage on deck, which is subject to seawater and capricious weather conditions. Further, the bill of lading is devoid of any reference to the Liberty Clause. Finally, the bill of lading stipulated that the cargo must be stowed under deck and the carrier was not exempted from liability for loss and damage. However, The additional covers provided in paragraph 5.4 may be invoked as a last resort, since it provides coverage for unauthorized carriage of cargo on deck if separately agreed. If separately agreed to such additional coverage, which is unfortunately not the case since there is no additional coverage agreed upon with the scope as the information at hand imply. Now dispute settlement. According to paragraph 47, any dispute between a school and its members shall be settled through arbitration, seated in Oslo, of course, unless otherwise agreed upon. Each party shall nominate their arbitrator and the chairman will be agreed or chosen by the parties. If no agreement, the Chief Justice of the Oslo District Court will nominate him or her. The Norwegian law is chosen with an exception to the Insurance Contract Act of 1989. In conclusion, stowing of cargo on deck is a quasi-deviation that deprives standard ocean carriage of the limitation to liability regime provided in COXA, and no insurance coverage, of course, will be provided by SCOL to indemnify the shipper as provided in the presentation area. I hope that the information provided in this presentation will suffice. In case there is any further question or inquiry, please get me updated. Thank you for your attention.